Joining us now is Joseph Kotrie-Monson, a broadcaster and criminal defence lawyer. Joseph, it's good to have you with us.
Good afternoon.
We're waiting sentencing, of course, which is due to get underway at around about 1 o'clock. But first, your reflections on the fact that, Girl X and Boy Y have now been named.
Well, there's a general principle, and this makes me uneasy, there's a general principle that children are not named in criminal proceedings. And Kamali, there's a good reason for that, and that's that the overarching aim of our youth criminal justice system is rehabilitation, not punishment. That doesn't mean to say that anyone should accept or support the deplorable crimes that we're discussing here. Mm-hmm. But there are a number of reasons why some legal commentators, lawyers, and I have to say I share some of these views, are a little bit concerned. Mrs. Justice Yip said it was in the public interest to name this boy and girl. The reason for that was that otherwise the public discourse would somehow be inhibited. Mm-hmm. Well, I'm not sure that follows, and others have said the same thing. We've been able to discuss boy X or these children as X and Y. We've been able to discuss them, and actually there's been massive interest. And there's a real danger about when public interest crosses over into public shaming and also notoriety.
I spoke to one of your esteemed colleagues earlier, Wendy Joseph, who mentioned there is a deterrence factor in the naming and the releasing of images like that. I suppose with the argument that you're presenting here, you don't think that deterrence factor would be enough to release the names and the images?
I think deterrence is overstated to a massive extent when it comes to youth criminal justice, because the idea of deterrence implies the following. There are, at this moment, would-be child killers who not only think that they're going to be caught, which most children don't when they do a bad thing, but they will be not only sentenced to a long time, but also, finally, that their names will be published and it will perhaps reflect on their families. As if that is something that is going to go through somebody's mind to the extent that they're deterred from committing murder. That simply doesn't make sense, I think.
I mean, she didn't say it was the only reason, but it was part of her argument, to be entirely fair to Miss Joseph. What about, the principle of our court system that justice must be seen to be done? And in this instance, the naming and the seeing, they are going to be 18 very soon. Is relevant.
Well, I think that justice must be seen to be done, and I think that's absolutely right. It's something I'm always harping on about in interviews such as this. But one very important factor here is the long-term protection of the public. Do we want branded, notorious criminals in prison who are on a rehabilitation path that is likely to be impeded as a result of them being named at the peak of the public focus, and dare I say it, almost frenzy in some quarters, certainly morbid curiosity among some. I'm not talking about families, but I am talking about people who think, well, I'm very angry, I want these people to be punished. This is not... These children will come out of prison, Kamali. These children will come out of prison either as dangerous or more dangerous, or they will come out with a chance of being rehabilitated. My overwhelming concern is that that is what's being impeded by this decision.
You think that there is a real risk of them not being rehabilitated, made more... the notoriety of their names and their faces being out there. And not to mention as well, I presume as well, as mentioned by Eddie Ratcliffe's family, the risk to them once they're incarcerated.
Well, there's the risk to them once they're incarcerated, and some of the comments, not just from the victims' families, the families of the perpetrators, but also, I think, Mr. Spooner, that making these children notorious, it shifts, if we want open justice, if we want a fair justice, a justice that really does a service to victims, is there a risk now that we are replacing those wonderful images and memories of a beautiful, bright young child with the two mugshots, fascinating as they may be to some people in the years to come, of two child killers? I actually think that that is an element of our open justice that's being overlooked in this decision. I think that there's a tremendous concern in the judiciary about being soft on criminals or being appeared to be soft on criminals. And I have to say, I don't find the logical gymnastics in the judgment from December to be persuasive.
Joseph, it's really good to get your legal opinion on this matter. Really appreciate you coming, Joseph Kotrie-Monson. Thank you so much for that.